Hello friends, today I'll be discussing with you official liquidators, companies authorized to register under the Companies Act 2013 and winding up of unregistered companies. These concepts have been dealt in Part 4 of Chapter 20, Part 1 and Part 2 of Chapter 21 respectively. Let's first try to understand the provisions relating to antecedent and other transactions. The Companies Act 2013 deals with fraudulent preference under Section 328. The power under this section is to be exercised by the tribunal. The expression fraudulent preference is borrowed from the law of insolvency. According to that law, any transfer of property or payment made by a person who is unable to pay his debts in favor of a creditor with a view to giving him a preference over other creditors is regarded as fraudulent preference. If within 3 months an insolvency petition is presented against him and he is adjudicated insolvent, the transaction becomes invalid. Any such transaction entered into by a company within 6 months before the commencement of its winding up is deemed a fraudulent preference of its creditors and invalid accordingly. Section 328 provides that where a company has given preference to a person who is one of the creditors of the company or a surety or guarantor for any of the debts or other liabilities of the company, and the company does anything or suffers anything done which has the effect of putting that person into a position which, in the event of the company going into liquidation, will be better than the position he would have been in if that thing had not been done prior to 6 months of making winding up application, and if the tribunal is satisfied that such transaction is a fraudulent preference, it may order restoring the creditor to his original position before the preference was given. If the tribunal is satisfied that there is a preference transfer of property, movable or immovable, or the delivery of goods, payment, execution made, taken or done by or against a company within 6 months before making winding up application, the tribunal may order as it may think fit and may declare such transaction invalid and restore the original position. If the company is comprised in a lease to the company, vesting would be subject to the terms and conditions of the lease. In the case of official liquidator versus Venkataraman, a motor transport company was sued for a debt and attachment before judgment of its buses. The court passes a compromise decree under which 3 of the company's buses were given to the creditor. A few days later, the company went into liquidation. The liquidator claimed that the transaction was a fraudulent preference. Rejecting his stand, Chief Justice Chandra Reddy said, if a debtor prefers one creditor to another on account of pressure that is put upon him, the payment cannot be regarded as a fraudulent preference. Persons in charge of the management thought that it is profitable to discharge the debts by allotting some of the buses to the creditors. Thus, it appears that whether a transaction is a fraudulent preference or not does not depend on its results but on the intention of the debtor. The Act also deals with proceedings against delinquent officers under Section 339. This section deals with the liability for fraudulent conduct of business. It states that if in the course of winding up of a company, it appears that any business of the company has been carried on with the intent to defraud creditors of the company or any other persons or for any fraudulent purpose, the tribunal on the application of the official liquidator or the company liquidator or any creditor or contributory of the company may, if it thinks fit it proper so to do, declare that any person who is or has been a director, manager or officer of the company or any persons who were knowingly parties to the carrying on of the business in the manner specified shall be personally responsible without any limitation of liability for all or any of the debts or other liabilities of the company as a tribunal may direct, provided that on the hearing of an application, the official liquidator of the company liquidator, as the case may be, may himself give evidence or call witnesses. Where the tribunal makes any such declaration, it may give such further directions as it thinks proper for the purpose of giving effect to that declaration, and in particular make provision for making the liability of any such person under the declaration a charge on any debt or obligation due from the company to him, or on any mortgage or charge or any interest in any mortgage or charge on any assets of the company held by or vested in him or any person on his behalf, or any claiming as assignee from and through the person liable or any person acting on his behalf. Make such further order as may be necessary for the purpose of enforcing any charge imposed. Where any business of a company is carried on with such intent or for such purpose, every person who was knowingly a party to the carrying on of the business shall be liable for action under section 447. This section shall apply notwithstanding that the person concerned may be punishable under any law for the time being in force in respect of the matters on the ground of which the declaration is to be made. The explanation to the section explains the concept of assignee and also that an officer, which includes any person in accordance with those directions or instructions the directors of the company have been accustomed to act. Now let us discuss various provisions contained in Part 4 of the Companies Act which deal with official liquidator. Section 359 deals with appointment of official liquidator. For the purposes of this Act, so far as it relates to the winding up of companies by the tribunal, the central government may appoint as many official liquidators, joint, deputy or assistant official liquidators as it may consider necessary to discharge the functions of the official liquidator. The number of such appointments is to depend upon the requirements of the situation. They are to be the whole-time officers of the central government. Their salary has to be paid by the central government. The Act under section 360 deals with powers and functions of official liquidators. It provides that the official liquidator shall exercise such powers and perform such duties as the central government may prescribe. Such functions may include those of a company liquidator under the provisions of this Act and conduct inquiries or investigations in matters arising out of winding up proceedings. Talking about summary procedure for liquidation. Section 361 provides that where the company is to be wound up under the Act has assets of book value not exceeding 1 crore rupees and belongs to such class or classes of companies as may be prescribed, the central government may order it to be wound up by summary procedure. Where any such order is made, the central government shall appoint the official liquidator as the liquidator of the company. He shall forthwith take into his custody or control all assets, effects and actionable claims to which the company is or appears to be entitled. Within 30 days of his appointment, he has to submit a report to the central government in such manner and form as may be prescribed, including a report as to whether, in his opinion, any fraud has been committed in promotion, formation or management of the affairs of the company. In case the report is positive, the central government may further direct investigation into the affairs of the company and that a report shall be submitted within such time as may be specified. The central government has then to order whether there will be full procedure winding up or summary procedure. Another provision relates to the sale of assets and recovery of debts due to the company. Section 362 provides that the official liquidator shall expeditiously dispose of all assets, whether movable or immovable, within 60 days of his appointment. He shall serve a notice within 30 days of his appointment, calling upon the debtors of the company or the contributories to deposit within 30 days with him the amount payable to the company. Where any debtor defaults, the central government may, on an application made to it by the official liquidator, pass such orders as it thinks fit. The amount recovered shall be deposited by the official liquidator in accordance with the provisions of Section 349, which talks about payments into public account of India. Then there is settlement of claims of creditors by official liquidator, which is dealt by Section 363. It provides that the official liquidator within 30 days of his appointment shall call upon the creditors of the company to prove their claims in such manner as may be prescribed within 30 days of the receipt of such call. The official liquidator shall prepare a list of claims of creditors in such manner as may be prescribed, and each creditor shall be communicated of the claims accepted or rejected along with reasons to be recorded in writing. Now, talking about the provision dealing with appeal by creditor, that is dealt by Section 364. It provides that an aggrieved creditor may file an appeal before the central government within 30 days of the decision. The central government may, after calling the report from the official liquidator, either dismiss the appeal or modify the decision of the official liquidator. The official liquidator shall make payment to the creditors whose claims have been accepted. The central government may, at any stage during settlement of claims, if considers necessary, refer the matter to the tribunal for necessary orders. Section 365 of the Act deals with order of dissolution of company. The official liquidator shall, on being satisfied that the company is finally wound up, submit a final report to the central government. If there was a reference to the tribunal, the report has to be submitted to the central government and the tribunal. The central government or the tribunal is then to order that the company be dissolved. The registrar shall then strike off the name of the company from the register of the companies and publish a notification to this effect. Chapter 21 of the Companies Act 2013 has two parts. Part 1 deals with companies authorized to register under the Act, and Part 2 deals with winding up of unregistered companies. Now, let's discuss them separately. Firstly, talking about companies authorized to register. Section 366 of the Act deals with companies capable of being registered. It states that for the purposes of this part, the word company includes any partnership firm, limited liability partnership, cooperative society, or any other business entity formed under any other law for the time being in force which applies for registration under this part. With the exceptions and subject to the provisions contained in this section, any company formed, whether before or after the commencement of this Act, in pursuance of any Act of Parliament other than this Act or any other law for the time being in force or being otherwise duly constituted according to the law, and consisting of 7 or more members, may at any time register under this Act as an unlimited company or as a company limited by shares or as a company limited by guarantee in such manner as may be prescribed, and the registration shall not be invalid by reason only that it has taken place with a view to the company's being wound up, provided that a company registered under the Indian Companies Act 1882 or under the Indian Companies Act 1913 or the Companies Act 1956 registered in pursuance of this section. A company having the liability of its members limited by any Act of the Parliament other than this Act or by any other law for the time being in force shall not register in pursuance of this section as an unlimited company or as a company limited by guarantee. A company shall be registered in pursuance of this section as a company limited by shares only if it has permanent paid up or nominal share capital of fixed amount divided into shares also of fixed amount, or held and transferable as stock, or divided and held partly in one way and partly in other, and formed on the principle of having for its members the holders of those shares or that stock and no other persons. A company shall not register in pursuance of this section without the assent of a majority of such of its members as are present in person, or where proxies are allowed by proxy at a general meeting summoned for the purpose. Where a company not having the liability of its members limited by any act of parliament or any other law for the time being in force is about to register as a limited company, the majority required to assent as aforesaid shall consist of not less than 3/4 of the members present in person, or where proxies are allowed by proxy at the meeting. Where a company is about to register as a company limited by guarantee, the assent of its being so registered shall be accompanied by a resolution declaring that each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member, or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company, or of such debts and liabilities as may have been contracted before he ceases to be a member, and of the costs, charges and expenses of winding up, and for the adjustment of the rights of the contributories among themselves, such amount as may be required, not exceeding as specified amount. In computing any majority required for the purposes of subsection 1 of this section, when a poll is demanded, regard shall be had to the number of votes to which each member is entitled according to the regulations of the company. Talking about vesting of property, all property movable or immovable, including actionable claims belonging to or vested in a company at the date of its registration in pursuance of this part shall, on such registration, pass to and vest in the company as incorporated under the Act for all the estate and interest of the company therein. Let us now discuss about winding up of unregistered company. The expression unregistered company includes any partnership firm, limited liability partnership or society or cooperative society, association or company consisting of more than 7 members at the time of the petition, but does not include a railway company incorporated under any Act of the Parliament or other Indian law or any Act of Parliament of the United Kingdom. A company registered under the Companies Act, or a company registered under any previous company's law and not being a company, the registered office whereof was in Burma, Aden, Pakistan, immediately before the separation of that country from India. Section 375 states, subject to the provisions of this part, any unregistered company may be wound up under this Act in such manner as may be prescribed, and all the provisions of this Act with respect to winding up shall apply to an unregistered company with the exceptions and additions mentioned under this section. No unregistered company shall be wound up under this Act voluntarily. An unregistered company may be wound up under the circumstances, namely, first, if the company is dissolved or has ceased to carry on business or is carrying on business only for the purpose of winding up its affairs. Second, if the company is unable to pay its debts. Third, if the tribunal is of the opinion that it is just and equitable that the company should be wound up. An unregistered company is to be deemed to be unable to pay its debts if a creditor by assignment or otherwise to whom the company is indebted in sum exceeding 1 lakh rupees has served a notice, but the company has not settled with him for 3 weeks. If any case has been filed against a member for a debt due from the company or from the member in his character as member, and the company has not within 10 days settle the demand, or procure the case to be stayed or indemnified the member against the sum due and the expenses, etc., if any execution or other process issued on a decree or order of any court or tribunal against the company or any member has been returned unsatisfied in whole or in part, if it is otherwise proved to the satisfaction of the tribunal that the company is unable to pay its debts. Section 376 deals with winding up of foreign companies. Where a body corporate incorporated outside India which has been carrying on business in India ceases to carry on business in India, it may be wound up as an unregistered company under this part, notwithstanding that the body corporate has been dissolved or otherwise ceased to exist as such under or by virtue of the laws of the company under which it was incorporated. Section 377 deals with provisional, additional, not derogatory. The provisions of this part with respect to unregistered companies shall be in addition to and not in derogation of any provisions hereinbefore in this Act contained with respect to the winding up of companies by the tribunal. The tribunal or official liquidator may exercise any powers or do any act in the case of unregistered companies which might be exercised or done by the tribunal or official liquidator in winding up of companies formed and registered under this Act, provided that an unregistered company shall not, except in the event of its being wound up, be deemed to be a company under this Act, and then only to the extent provided by this part. That was all about today's topic. Hope you have understood it properly. Thank you for watching.